Good morning. My name is Justin Connell. I'm with Ellerby Thompson, and
I'm Lael Bellamy, and I'm with ING.
we are here to talk about social media today. Glad you guys could join us. As we go through, we will tell you which slides that we're on as we go through the process today and through the program. And for those of you keeping up at home there, you can flip along with us. If you want to quickly turn to the second page, which is the mission of the Pro Bono Partnership of Atlanta, and you guys, can feel free to read that. If you will move on to the third slide there, and that is the Pro Bono Partnership of Atlanta, the eligibility and other information that you can find about Pro Bono Partnership of Atlanta. If you are not a client of Pro Bono Partnership of Atlanta, you can sign up for information through the link that will be provided on the last slide of the presentation today. We want to extend our thanks to Georgia Legal Services for providing the webcast platform today, and also to TechBridge for its collaborative efforts in what we hope to make this a successful webcast. We are lawyers, so we have to give a disclaimer, and our legal disclaimer is that the information that we provide in the webcast today is general information and does not constitute specific legal advice.
And our comments are our own, not our company's.
There you go. We're going to get to that later on. But if you do have questions, don't hesitate to contact Pro Bono Partnership. That's what they're here for, and that's what you're here to hear about today. So if you want to, we will move on to slide number 4. And as I discussed earlier, we're going to be talking about social media today. We hope to keep this informative for you guys and provide some useful information, and keep it lively and hopefully not put you guys to sleep. We are in some uncharted territory with respect to the economy, and what we would like to do is keep our advice for you guys, or our suggestions for you guys, with an eye and ear gauged towards the economy. I mentioned that a partner in my firm used to say that the perfect client, or his ideal client, is principled and solvent, and we're going to try to keep you guys hope that you're solvent without having to show how principled you are. We're kind of provide you with an agenda today. The agenda is going to tell you where we're going to go. I would like to first of all, we'd like to outline what social media is, identify potential legal issues you guys may face, provide you with some hypotheticals, ways to protect yourselves, and then give you some best practice tips to kind of take away from this. For nonprofits, social media provides a wide variety of opportunities, but with those opportunities, risk and issues also arise. Opportunities of positive PR, low-cost communications, recruiting, fundraising, those are all examples that you guys, I'm sure, see every day with social media. But at the same time, we want to make you guys aware that there are some issues that do arise with respect to monitoring and privacy, legal issues that arise. Defamation is just one that we'll get into later on today. If you will turn to slide number 5 today, and that's where we start to define what is social media. And social media is an umbrella term that's used to describe social interaction through the internet or through web-based technologies. And social media is all around us. We all know that. We can see it every day. So I'll now turn to slide 6 and kind of get into what does that really mean. And Lil can take over from here.
So there are different ways to set up your website. I think a lot of times when people think about social media, they think about Facebook, and they think about the two-way interaction, and that can bring some liability to companies. One way to think about it is to think about having a one-way communication, and also to use social media to have a presence, because that's very important. Just like 20 years ago, people would call up and say, gee, should we have a site on the internet? And there was a lot of debate about that. Well, people are trying to have the same conversation now. You should probably have a social media site. But whether you want to have the full-blown site or to have something easier, just maybe a one-way site or something that you should consider. And one of the examples that I give, because I have a new puppy, is that having a social media site is like having a new puppy. And you do have to get up in the middle of the night sometimes, and you can't just leave the puppy alone at home by itself over the weekend ignoring it. So I think if you look deep into yourself and think, wow, I really would like to get a puppy for some event, or to have a social media site, and think, do I really have the time and the energy and the money to take care of all of this, or would it be better to have something else? So one example of the one-way site, and there's several good ones, are you can have a place that actually deep links back into your website. So if you have a place on your website to for donations, for volunteering, for other sorts of things, you can have the link on your social media site that looks very interactive, looks like it's there, but it's really taking you back to your website. So that's one way to do it, to have a frozen page, to not allow the sort of ongoing chatter, where you can review content yourself ahead of time. You can review, the posting, so people don't put things up. And that is part of the problem with social media is that review and that constant review. There are some tools, and there, like if you go to Google, there's some tools that can email you about it and give you alerts that they're there. But again, it's almost a 24/7 job.
Yeah, the constant monitoring of social media. I had a great time in college, and I know that kids will do dumb things in college, and they will post incredibly dumb things over the internet. I know that you are amazed by that, and probably more amazed by that after these kids have posted something and they show up at your organization looking for a job. But as a litigator, social media plays a role in 99% of the cases that I'm involved in. I would say 100%, but the lawyer in me won't let me do that. It's only 99%. But it's a great way for plaintiffs' lawyers and defense lawyers to both gather information that's out there, that's free and it's available, and you don't have to go through the legal process to do so. So it is a very important tool, but at the same time, it does require a lot of care and a lot of protection, and not only for individuals, but also for your organizations. Just some statistics that I found that were just incredible, that these statistics were by the end of 2010, that there were 156 million blogs worldwide. There were 140 million tweets every 24 hours, and that with respect to YouTube and YouTube views, that there were more videos that were uploaded to YouTube in 60 days than the three major media outlets produced in 60 years. And that's ABC, CBS, and NBC. That over 60 years of broadcasting, YouTube was able to do what they did in 60 years in 60 days. So that was just a phenomenal statistic that I saw that showed social media and what a big part of our lives it has become. If you want to flip to slide 7 now, this is, as Lael mentioned earlier, Facebook is probably the most prominent that's out there now that we know with respect to social media. It's the most used social network worldwide now, and it's open to anyone 13 years and older. Which, in light of the recent events that are in the news, is kind of a scary thing in and of itself. So I don't know if you had anything to add to that.
I think one of the things that people get confused, both clients and also people who work for you, they get confused between their public persona and their private persona, or their at-home persona and their work persona. And especially if somebody is very vocal or appears to be speaking for your organization, it's very important that their work persona is being portrayed. So I think sometimes people think, well, that's very invasive, it's very difficult. There are ways to separate it, and we're going to go through some of those tips here. But it's important to think, especially when you're loading content, when you're loading pictures, when you're doing these things, you have to separate how you work your home Facebook page from how you work your business Facebook page, and you are held to higher responsibilities as business.
Absolutely. And if you guys want to turn to page 8, there's an example of a Facebook page there. This is, you probably recognize Mark Zuckerberg. He is the founder of Facebook. He's 27 years old now, and he has an estimated net worth of $17.5 billion, which generally comes from the equity that he has in Facebook. So he may have been onto something there with that idea. But if you guys want to turn to page 9, we'll get into Twitter and Twitter basics. Twitter's a different animal in and of itself. It's come along here in the last 2 or 3 years and gained popularity, mainly with celebrities. Tend to rely on Twitter and submit their tweets. Tweets are text-based posts that are sent from a page that an author can send to their followers. You can see tweets, different celebrities, sports icons using them all the time. So that's something. There were, I guess there was another statistic. I'm big on these when it tries to give the effect of something that's important. That there are 200 million users on Twitter, and they're generating 190 million tweets per day. and that's up 50 million in 1 year. So as you can kind of see the progression of Twitter and where Twitter is going, and anyone can sign up and get a Twitter account. It's very simple. Twitter use by category on slide 10. It's a little pie chart there that breaks out the Twitter use, and if you'll turn the page to 11, the slide says surprise, but it's probably no surprise that the majority of tweets are pointless babble. To make a little jab, I did say that celebrities are the main users of Twitter, so that is not surprising. Conversations comes in second there, but news and self-promotion are under 6%, and self-promotion is something that your organizations, I'm sure, will use a lot, and your employees may be using it with Twitter as well. If you'll turn to slide 12, we'll get into another social media component, LinkedIn. LinkedIn, as you already probably know, LinkedIn is more of a business-oriented social networking site. It's more of a professional networking. You can ask people to join your LinkedIn connection. You connect with other individuals, and it's also another useful tool within organizations. Flipping to page 13 or slide 13, more LinkedIn information there. LinkedIn is monthly U.S. visitors are over 21 million, and then 47 million globally. So LinkedIn also encompasses a large group, and that's another thing to remember. I guess important to point out about the internet is that when you're talking about the internet, you're not only talking about within this country or not. It's global. The internet's global. So what you put out there is out there for everyone to see.
Forever.
Yeah, forever. And if you want to flip to the slide 14, there's existing laws that apply to social media.
So certainly there are state and federal laws which apply to social media. A really good resource, and there are several, is ftc.gov. And that's a wonderful place. They have a number of small media or small company guidelines and videos and things that you can play for yourself. But it's also important to note that your own policies will also affect how you use your social media. So if you say, we will never sell our data to anybody, or we will never do X, Y, Z. If you then sell your company or you merge with another company, that is held to be your law. So if you're more restrictive than you need to be, it can cause you problems later. So it's really important. I think sometimes people are like, find something online or call a friend and say, hey, give me a social media policy. You have to read the social media policy carefully to make sure that it is what you intend to do with the data. And if you do want to save data or use data in the future for all kinds of good reasons, you just want to make sure that you don't hem yourself in by saying something that you don't intend to do, because that will get you into trouble. There are other things to think about too. I think sometimes people are used to seeing pictures that everyone throws up. People do have a right of publicity, so there's some really interesting lawsuits out there. RJR had put some pictures of priests in their advertising. A priest sued because they didn't want to be associated with that advertising. So you do need somebody's permission to use their photos. And so whenever you're taking photos, you should try to get photo releases. And certainly some of you, based on the types of work that you do, should also be very sensitive about posting pictures of children. There certainly can be issues of safety as well as privacy if you post pictures of children or abused spouses or whatever it might be. You want to make sure that that they can't be tracked down, and so you have safety issues as well there. Another issue that has come up in the past here at other organizations is defamation. So if someone who was for instance, a battered spouse decides to tell their story on their site or on your site, the other spouse might say there's no evidence of this and sue the organization. So you do need to be careful too about the kinds of things that you're posting and look at it from all angles. There are also issues with content posting, because a lot of companies sell their content. That's how they make their money. So just because you find a really cool article on the New York Times or at the Atlanta paper, some other place, you really need to check and make sure that you're allowed to post it on your site. And this is a huge place where it's different between what you can do at home and what you can do when you're in a business or when you're running a nonprofit. So a quickie thing that you can do is go to the bottom of the page where you see the content and read the terms. And I know that it's really long and super boring, and Pro Bono Atlanta can probably help you come up with some content too. But you do need to read that and see what the rules are about posting. And frequently, you can just get permission from somebody to post. So you can call them up and say, "Loved your article. Would it be okay if we put this on our social media site or on our website?" And frequently, they will, especially if you explain what you're doing, they will say absolutely. So just keep that. A great story that I had there was a friend of mine who's an intellectual property lawyer actually had gotten permission to use picture for her company's annual report, and had paid the photographer $10,000 to use the picture. Well, they didn't have a very good agreement in place, and the assumption is that the rights are the right holder, so the photographer owns the rights unless it clearly says you have the rights to use this picture forever. So everybody loved the picture, tried to use it the next year, and the photographer sent them a bill for another $10,000 because they used it twice. So the assumption is if it's just one use, unless you get permission to use it longer. So you need to be very clear. And sometimes with newspapers, it's above the fold, below the fold, how big the picture can be. So those are just some things to take into consideration.
Here's one question. Should that type of permission be received in writing?
Yes. It's very helpful for you to try to get. The question was, should the permission be received in writing? It's very helpful to get that permission in writing. An email will do, and just keep it for your records. But it's very helpful to try to get that in writing, so you'll have it in the future. On the next page, page 15, we're just talking about your privacy policy here. There's more of a movement for people to put privacy policies on their social media sites. So everyone's required to have a privacy policy for your web page. Typically, you should also think about putting one on your website or your social media sites, especially if you're pulling any information off. And so here are some places where you really need to be careful and to get legal advice before you do these things. So if you're going to be collecting, storing, and using data, so you can pull a lot of information off the Facebook site. You can pull whether people are married, what their birthdays are, where they went to school, the things that they like, and know that people are doing this on your web pages too, on your personal ones, so you should be concerned about that if you don't want to share. But you should also ask your service providers, because frequently if you get somebody to do this for you, they may be pulling your information off and saving it because they think you might want to use it later, but they may not tell you. So it's important to ask. You can ask to see wireframes and to actually see data flows and see what data is being captured. And I always say captured, stored, and used, because sometimes they capture it, but then they dump it. You still need to be clear with people about what you're doing with their data. So we talked already about third-party rights. You should be very careful about promotions and contests, because it's very easy to fall into an illegal lottery, and there are a lot of people who can get, sometimes there's a personal cause of action. If you screw it up, you don't want to have to give everybody a car or an iPad or whatever interesting thing that you might have that you want to hand out. There are also some new rules about testimonials, both celebrity testimonials and personal testimonials. So before somebody gets on and says, "I've used this fabulous thing," or "I think this is wonderful," make sure that they have, and there's some really good guidance on the ftc.gov website about that. Again, be very careful about minors, and make sure that you get releases from their parents before posting information. There's a lot of hubbub now about location information, so you should be careful about posting information, and certainly before you collect location information on people. There's a lot of class actions on this, so you should be careful there too. So another question?
Yes. Where do you put a privacy policy on a social media page?
You can usually do a link on the bottom and sometimes along the, oh, I'm sorry, the question again was, where should you put a privacy policy on a social media page? You can do it as a link that just probably takes you back to either your website privacy policy if it's the same, or it can take you to a different place on the web to have it. And you can work with your service providers to figure out the best place to put it. And there's some good ones. If you go out and look at the Coca-Cola site, it doesn't look like a regular privacy policy. It's we take down mean stuff, be nice to other people, It's more colloquial, friendlier, and here's actually a perfect example of what you should be doing on page 17. So here's an example of big whoops through the American Red Cross. So somebody associated with the Red Cross posted a thing about going out and getting drunk. And then the Red Cross responded very quickly saying, we've delegated the rogue tweet, we've deleted the rogue tweet, but rest assured the Red Cross is sober and we've confiscated the keys. So could have been a huge disaster.
Great response.
Great response. They, they caught it, they responded, they were glib but still serious. So these are some things, again, taking care of your puppy. You may want to have thought about these things ahead of time. And sometimes it's people think that they're being helpful. I saw one time where a former employee of an organization got into it with a blogger, and it just went on and on and on, and they argued back and forth. And you're almost better off on some of these. Most people don't go farther than the first page on Google and don't go farther than the first page on whatever the social media site is. So sometimes the response is just to post a bunch of stuff to push down whatever it is to the next page. Because sometimes when you delete it, the person gets even more mad and deletes back on. I work for ING, which is a sister company of ING Direct, the bank, and they do a wonderful job of responding to people's posts. So someone will have a bad experience and they'll say, well, so sorry you had a bad experience. We're here to help you. Dial 1-800. And we'll talk to you immediately and resolve this. So there's certain ways of doing that. Obviously, you don't want something like that, a grumpy post up there, and then nobody responds for days and days. And they probably have 6 or 7 people whose full-time job it is to monitor those sites and to put content up. So think about that. Do you have those resources to do that? Or should you just put up a static page with some links back to your site? So again, we're talking a little bit about some best practices here, but again, monitor, monitor, monitor. We talked about the static page. Do come up with an escalation process internally. A lot of companies come up with the worst case scenarios ahead of time. So if you can do the imagine what horrible thing could happen and then help develop a response together, sometimes that's very helpful. And also obtain releases before posting pictures. So now we're going to turn to Justin.
Yeah, we're going to now get into employers' responses to social media. And again, these are from a 2010 survey. These statistics go back, and the most glaring there I've tried to highlight is that 69% of companies do not have a written social media policy. I know that we've all heard this saying that, with these statistics that, there are lies, there are damn lies, and then there are statistics. But a recent survey showed that 43% of all statistics are completely made up and show no foundation. Just wanted to make sure you guys are still with me there. That was a joke. But with respect to social media, you've got real world implications. Several years ago, Domino's Pizza, who has actually done a great job in recent marketing of rebounding from what was a very bad situation. There was a small Domino's delivery franchise, actually, that a couple employees were sitting around on a Sunday and were very bored, and they decided to show you how not to make a pizza, and then actually show you delivering the pizza to a family, and it's not a pizza anyone would have enjoyed. That video went viral, and Domino's lost a large percentage of its market share. Now, Domino's did a great job in coming back from that, but Domino's has millions and millions of dollars in their marketing expense to be able to come back from that. There was also another video that went out shortly after the Domino's video from an emergency room of a pretty big research hospital, and it was some interns that were in their residency that were a little bored in the ER, and decided to post a few videos to YouTube, and those ended up going viral as well. Not a good thing for the hospital or for research funding for the next year. So just a couple things to keep in mind. As Lael pointed to earlier, the social media is an ever-evolving issue, and just because employees are at home doesn't mean that they can't affect your organization, or if you're not monitoring them doesn't mean that they can't affect the organization. So it's very important to keep up with that. Now we're going to flip over to turn over to slide 20, and this is if you've got any Eagles football fans out there, you're going to know what this one's about. There was an employee, Fan Dan, who was turned fan Dan. He was upset that the team, that the Philadelphia Eagles, the NFL team, had traded one of their best players. He changed his Facebook status, and the Facebook post that he posted is listed there on slide 20. If you'll flip over to slide 21, the problem there was that Fan Dan worked for the team. So he was employed by the Philadelphia Eagles, which is going to bring up and kind of set up some of the issues that we're going to be discussing today, is what happens when your employees post things on social media. How do you address those things? How do you react to those things? What are the proper responses? If we'll turn to slide 22, the Eagles management found out about the Facebook page. They terminated Dan's employment. The question is going to become, can employers consider an employee's use of text messaging, social media, when making employment-related decisions? Well, the answer is yes, they can, but there are some caveats to that, and there are some rules that we have to be aware of, and rules that have to be followed. So that's something I hope to get into in just a little bit and show you guys where to go there. Legal limitations. I'll give you a second to look over the legal limitations about disciplining and discharging employees if they express intent to raise an issue with management, or if they are identifying photos, logos, or other identifying information, which Lael spoke to earlier. So there are legal limitations on what you can do when employees post to social media.
You also look like a doofus if you respond with your typical lawyer response, both in the intellectual property world. People used to send really mean cease and desist letters, stop using our logo, don't do this. Well, guess what? It's super easy to post those now, and the company looks like a big, mean corporate evildoer. So
Yeah.
and the same way with a lot of these labor relations. Like, sure, somebody called their manager a weenie, but you looked like a bigger one because you fired the guy. So
Yeah, exactly.
your response is different. Talk to your marketing people and your lawyers, I guess.
Yeah, that's the key. If you'll turn to slide 24, this the National Labor Relations Act. Well, it's the slide says it's not just for unions anymore. I know you guys are sitting out there saying that the National Labor Relations Act doesn't apply to me. I don't have a union. I'm not dealing with unionized employees. Well, the NLRA, which is the act, is enforced by the NLRB, which is the labor board that oversees union activity. Well, the NLRA actually applies to both unionized and non-unionized employees. So your employees have protection under the NLRA, even though they're not unionized. And I guess the way to explain that is that the NLRB kind of saw how much fun the EEOC was having. And as you know, the EEOC enforces employment rights of individuals that are non-unionized. And they decided they wanted to get in the game. So that's where we are. They've placed limits on employers' reactions and actions to responses to employees' use of social media. And there are two kind of buzz phrases that I'm going to go over today, but I'm going to explain those to you, and tell you the best ways to avoid those. But it's protected concerted activity and mutual aid and protection. Those are kind of two buzz phrases that the NLRB looks to when enforcing actions that take place under the NLRA. And again, throwing a lot of acronyms at you, but the act is applicable to both unionized and non-unionized employees, and the gatekeeper, for lack of a better phrase, is the NLRB that oversees these. So even if you don't have unionized employees, you can still be dealing with the National Labor Relations Board, and they can send you one of those nasty letters, and you've got to respond to it. If you'll flip the page onto 25, it kind of shows you a little bit about the NLRA and explains a little bit, the slide there, about protected concerted activity, mutual aid and protection. The example that Lael alluded to earlier, an employee tweets that boss is a dirtbag that gives crappy raises to everybody. Company takes a hardline stance, or the organization, and you decide we just can't have that with our company, we just can't have that with our organization, fire this employee. Couple things can happen. The employee could then file a charge against you with the NLRB, and then the NLRB is going to get this charge in their door. They're going to take a look at it, and they're going to say, okay, does this employee fall under the act, which they do, and then they're going to take a look at it and say, well, how do we interpret this tweet of boss is a dirtbag that gives lousy raises. Is this person acting for the mutual aid protection of others, and is this protected concerted activity? Well, it all depends on basically, unfortunately, what kind of day the board is having when they decide to interpret this. It can go either way. The board can say that this individual was talking about raises and talking about their pay salaries and their salaries, and they can say that they can interpret to mean this employee was acting on behalf of other employees to try to get better pay for their coworkers, and therefore mutual aid and protection was on behalf of other coworkers, and now you as an organization have a problem. The board may say that that this individual was not acting on behalf of other individuals, they were acting on behalf of themselves, and then you don't have a problem. Now, the reason I say it can go either way, we're in a current political environment. Let me preface this by saying I hate Republicans, I hate Democrats, I have no idea what the Occupy movement is doing. Don't get me started on the Tea Party. So now that I've equally offended everybody, I can say that it is in the current political environment we're in. Our president is from the Democratic Party, which generally nominates more liberal-leaning interpreters of policy. So it's no surprise that with respect to a 3-member board in which the president is able to nominate 2 members of a 3-member board, that he's going to nominate 2 members that are more in line with his political leanings. His political leanings are more to expand the scope of the NLRA. So the individuals, the majority of the board, will interpret the NLRA with expanding the scope of that act. And that's just the nature of the environment we're in. If there's a Republican president, he's going to nominate 2 individuals that will look at the policy, look at the act based on his political leanings. So it's just a matter of who happens to be on the board at that time, and that's what the board will take a look at those things. But just based on decisions that have been handed down and looked at, and based on the policies and the procedures and the way things have been interpreted, that's my opinion as to the way these things are going. That's not the opinion of Pro Bono Partnership of Atlanta, and certainly not of Lael, her organization. So if you would turn the slide there to slide 26, how did we get to the place where we are, talking about how in the world can an employee post something that's degrading to my organization on a website, and I, as the buck stops here, owner of the organization, member in charge of the organization, how in the world can I not then take action and get rid of this employee for doing something that is inappropriate on a website that harms my organization? Well, there was the case in point is how we got here was a Facebook firing case, and that's on page 26. I'll let you read the facts of that case, but an ambulance service employee posted negative comments about her supervisor. An NLRB complaint was filed. The NLRB found that the employee, even though the employee was not a unionized employee, the ambulance service did not have a union, that this employee fell under the purview of the act, and the charge was filed. The company, the ambulance service, ended up reaching a settlement with the NLRB, and the litigation, so to speak, the interpretations followed from there. So up until September of this year, which I'll get into in just a few moments, we really didn't have any. There was no real precedent, no real decision that came down. All of the information that we had as lawyers to try to interpret what we were giving advice on what organizations could and couldn't do were coming down from a stance that was taken by the NLRB and reaching a settlement with a company. So we could see that a charge was filed and then the company reached a settlement. So we really didn't know where we were going. We knew where we were going. We thought we knew where we were going, but we had nothing really set in stone, so to speak. That later came just a few months ago. On the same note, on page or slide 27, the title of the slide there, Tweet Lightly, same type of scenario where an employee, in this case, tweets something. It could have been on a Facebook page, but this happened to be through Twitter, and it was a newspaper reporter that was terminated for posting unprofessional tweets. Well, the NLRB concluded in that case that the employee was discharged for misconduct and not protected concerted activity. So there the board found that this employee was doing something for their own benefit and for their own good, and not for the mutual aid and protection, or not for the benefit of others. So that's how the board found in that case. On to slide 28, I'm going to talk about a couple other issues that we get into with respect to social media before we go into that social media policy and what you guys really need to have in that policy as an organization, how you need to follow it. Falling into a lawsuit, which is discovery unnecessary information. Let's say you've got a candidate that you get the resume. This candidate looks great on paper, looks wonderful. You start researching this candidate online where information is available, and you find out some unnecessary information. This candidate may be pregnant. She may be wanting to take leave after she joins your organization. This candidate may be divorcing. This candidate, you may not agree with this candidate's sexual orientation, views on race, religion, immigration, what have you, disabilities. Well, ignorance is no longer bliss. The great defense that lawyers always had, we had no idea about this information prior to hiring this person. So that decision could not have factored in our decision not to hire this individual. The plaintiff's theories now coming into this are that this otherwise unknown information was available to you, and odds are you found this information out, and that's the reason you chose not to hire this individual. If you'll turn the page, there's a little bit we get into a little bit of this about pre-employment internet screening. An important note there, not all applicants tell the truth. I know it doesn't surprise any of you, but that's where we are. A little bit on page 30 or slide 30 there is what I was talking about, disparate impact claims. Slide 31 is discrimination claims, and what I can do now on slide 32 is kind of get into the applicant screening. I'll go back and explain those slides to you. That was just a little bit more about background information of what kind of suits that we're talking about. The classic example would be you get as I said, a great resume in. You find out that the individual, you do some online research, you find out the individual is disabled, and you would have to make significant changes within your organization to have a disabled employee work there. So you decide not to hire that individual, you decide to hire another individual. Well, that's going to be an impact claim from the standpoint that that individual could potentially hire a lawyer who could then sue your organization and say that there was a reason. The reason that you did not hire that individual is because you found out that they were disabled and that they had a disability. And now you've been sued because you chose not to hire someone because of a disability. So a lot of things can go into this. There are a lot of pitfalls out there. But at any rate, getting back to pre-employment applicant screening, there's some important things we want to point out. If you're going to do screening on applicants when you get the resumes in, if you're going to look at them, a couple different tips to follow. One is have the non-decision maker conduct the search, filtering out protected class information. That would be things that we've discussed: sexual orientation, gender, age, disabilities, those things, so that the decision maker truly is ignorant of all that information. The individual making the decision is completely unaware of any of that information and makes the decision based on the best candidate for the position. The hiring decision has to be still supported by legitimate non-discriminatory reasons, and always document. As Lael said earlier, one of the questions was, do we get the what am I looking for here? Do we get the answer in writing? The permission, that's it. Permission in writing. Absolutely. Document everything. And there are some FCRA requirements. I don't know if you wanted to speak to those.
Sure. The FCRA is a passion of mine, and not that many people have know about it. So typically what had happened years ago was that people were making adverse decisions about other people for employment, for rental property, for insurance, and they were basing it on a huge big database that hadn't been that hadn't been vetted. So there was incorrect information on there. So you weren't getting a job because somebody thought you were an axe murderer, but nobody bothered to tell you that, so you could clear it up. So the FCRA stands for the Fair Credit Reporting Act, and there's actually some terrific information on it on the ftc.gov website too, so you can go there and check. So that's the law that says that before you do a background check, you need to go ahead and get a signature permission before you do that. If you make an adverse decision about somebody based on a credit report, you need to tell them, I'm not hiring you because the credit report says you are an axe murderer, or or that you have a felony. And then that gives you the ability to go back and check to see what your credit report and your employment history actually say about you. You can actually get a lot of those reports for free. The ftc.gov site tells you how to get your credit report for free. You're able to get one free per year. Always a good idea to check that, especially right before Christmas. Many of the employment background check companies are required by law to tell you what the file says on you. So that's another thing that you can do, is go request all your records to see what it says, and then there's a process to follow to correct that information. I think a growing body of law is now, Facebook is problematic because it doesn't have a social security number on it. So it's a catch-22. Obviously, you don't want your social out there. On the other hand, a lot of people have very similar sounding names. You don't have to be John Smith to get confused with a lot of other people. So it's possible that you go on, you say, oh, I got this resume in, I'm going to look them up online. It could be totally a different person. There are people with the same names who went to the same schools, who live in the same area, even if they have an unusual sounding name. There's a terrific website called howmanyarme.com, RAREME, and you can put your name in and it'll say there's 75 of these people in the United States. So you'd really be surprised. I think that it's ripe for future employment, because somebody who's got a Girls Gone website who has the same name as somebody else isn't going to get a job, and they're going to start getting mad, and it's something that a lot of people can get behind. So verify the identity.
Absolutely. Great points. With respect to, I guess we can turn now to slide 33. With respect to pre-employment and screening, these are some tips here on how to implement that. If you're going to screen, then screen all applicants. If you're not going to screen, then don't screen any. So it's all or nothing. That's a helpful tip. Another is to have HR employees or supervisors trained on this, so that they are basically a Chinese screen from the information that is found out about applicants, and then verify information. Very important if you're going to screen. So those are things to take away from screening applicants. Going to get into, is there anything else? Well, absolutely. Social media really is the day and age where, just because an employee is no longer with you doesn't mean they can't affect your organization. So we're going to get into some of those things as we go forward. Slide 35, workplace harassment issues. We're going to go through this pretty quickly. It's pretty standard stuff, but you would be amazed at the reason some of this stuff is in here, and it is in here for a reason. That means that there was actually a case on this, and that someone actually did this. I do a lot of employment law litigation, and I'm never surprised at some of the things that I read and see. So it's these things are in here, and they're in here because they've actually happened. So let's see what not to do. Nude or obscene photos, that has happened. Happens all the time, actually, unfortunately. But these are just some points here of what not to do with respect to social media. This can get you into some harassing issues and harassment issues really quickly. For example, if your employees are using your organization's social media to communicate with each other, or harassing and bullying another employee, those things can come to light, and social media will capture it, and that's not a good thing for your organization. I know you guys are probably like me and don't have a couple $100,000 sitting around in your litigation budgets to budget for things like this. So it's important to prevent these things from happening, and the way you prevent them from happening is get a policy on them and outline them, and when they do happen, take action. But take reasonable action. I think that's the key, is what Lael was trying to allude to earlier. You got to be reasonable with your decisions. Again, on slide 37, we are not joking. Unfortunately, these things also happen. We see them every day. Just some other outlines. Slide 38, a guy who really had a great NFL football career and unfortunately is probably going to be remembered not by so much what he did in his career, but what happened at the end of his career. I think we're all seeing that play out again in the football context in the media right now. It's just really unfortunate situations. And Brett Favre is the individual here on 38. Did the same thing. I'm sure you all have heard about the Brett Favre issue back in 2008 where he sent some sexually explicit voicemail text to graphic pictures to a reporter. The reporter was actually employed by the same organization that employed Brett Favre. If you'll turn to slide 40, you'll see where an investigation was conducted. And the key to take away there is what we've been hitting on with social media all day, and that's that what we consider off-duty conduct can still become unlawful and can still impact your workplace and your organization. If you will turn to slide 41, we're going to go through these, and this is kind of how to avoid pitfalls. Develop a social media policy that's right for your organization, implement the policy, and then follow that policy. It's kind of a written it gives you a roadmap as to what to do when certain situations arise. Pro Bono Partnership of Atlanta, you guys contact them when you have those questions. They'll be happy to help you through those, hopefully, and we will move on. Slide 42, basic policy contents. I want to run through now what should go into a social media policy, things to watch out for, things to make sure that are in there, and then things to follow up on. As I mentioned earlier, as we mentioned earlier, the disclaimer is very important in this day and age to have a disclaimer. All employees, when posting things, should issue a disclaimer that they're not it's not the views of the organization, but it's their own views. I said earlier that how we got to the situation where the NLRB was stepping into employment context where there were no unions. You saw how we got there with the ambulance case. Well, in September of 2011, we had our first decision that gave us some insight into where we could expect to go from there. And it was the board issued its first ruling of its kind, September of this past year, out of Buffalo, New York. A nonprofit organization was found to have discharged 5 employees for Facebook postings. The board found that the Facebook postings were at the mutual aid and consent or mutual aid and protection of others, that the individuals were talking about workload and staffing issues in a Facebook post that they made. The nonprofit organization did not like the PR that came with that, so they terminated these 5 individuals. These 5 individuals go to the NLRB, file a charge. The NLRB buys their case, says what they're, trusts what they're saying, advocates on their behalf. This goes before an ALJ, an administrative law judge. An ALJ rules in favor of the board and the 5 employees from the nonprofit. The ALJ ordered that the 5 individuals be reinstated, they be awarded back pay, that notice postings take place, that training be conducted, and that quarterly audits are conducted of the nonprofit. The reinstatement and back pay are one thing. Those are expensive items in and of themselves. However, the training and quarterly audits become very expensive endeavors. And like I said earlier, for nonprofits and other organizations that don't have budgets of hundreds of thousands of dollars in their legal fees, this is going to become very expensive for this nonprofit.
2 questions.
Sure.
The first, what types of disciplinary actions are appropriate to enforce when an employee violates the social media policy?
Okay. First question is, what types of disciplinary actions are appropriate when an employee violates the social media policy? That's kind of there's a lot of factors that go into that. Discharge may be appropriate depending on the nature of the offense. There's a lot of, again, a lot of factors go into that. A written warning may be appropriate discipline. Just a wide range of varieties that can go into that, depending on the level of the offense, based on the content that I guess is conveyed. Would be the best way to say that. But that's more of a case by case basis based on what the individual has actually done.
Can a social media policy, though, override what the NLRB has said would constitute aiding your coworkers? So in other words, can you just eliminate that rule because you put it in your social media policy that you can't do these things?
No, and that's a good point to raise. The question was, can the social media policy, can it be overridden by the NLRB, or can you override the NLRB with your social media policy? And no, you cannot. The NLRB will take a look at your social media policy, and that will be the first thing that, when a charge comes to the NLRB, the first thing they're going to do is ask for the social media policy. They're going to want to take a look at your policy because they may take the view that it chills activity. And I don't want to get into that because it's too legal of a discussion. But the short answer is no, your policy cannot override the NLRB. The NLRB is going to interpret your policy. They're going to look at your policy. They're going to look at the action that was taken. They're going to look at the conduct that went into the conduct that led to the disciplinary action, and then they're going to look at the action taken by the organization. So that's kind of the short answer for that one. But I'll be glad to take follow up questions on that, because that gets more into a very legal conversation.
Okay. Should nonprofits also have policies for employees who manage social networking sites on behalf of the organization?
Should nonprofits have? The question is, should nonprofits have? And you'll have to help me out there.
Should nonprofits also have policies for employees who manage social networking sites on behalf of the organization?
I don't think so. What do you think?
I don't think so, and I would try to repeat the question so everybody could hear it. But basically, should nonprofits have, I guess, individual policies for certain individuals that oversee the social media sites for, I'm trying to think too far ahead, for the social media sites. And no, I agree with that. I don't think so. I think that what you have is you have one social media policy, and that social media policy is applicable to all employees, whether or not they're overseeing the site or whether or not they're contributing to the site.
You may have a policy about how people can view confidential information, but that would be true for anybody in your organization.
Can a nonprofit have a policy that guides the people that work on their social media as to what kind of content they would like on the site and information they want to share with the world on their site? As an employee, sort of directing the employee what we expect on our site. Your job is to put the information on the site. Here's the type of information we want. Here's how we want it.
I think that's more of a governance policy. A lot of companies will have the question was, should you have some kind of policy about what people can post or what people can put on the site? So I do think you can have guidelines there. I do think that many companies have a cross-functional team who actually reviews the governance. They review content ahead of time. In certain industries, you absolutely have to preview content, like the financial services industry. Content could be considered an advertisement, has to go to FINRA to be approved first. But typically that wouldn't rise to the level of what we have here. But many people will review it both from, because you have a different view, whether from an HR standpoint, do you own the content that you're posting? Is the content you're approaching appropriate? The marketing people too, obviously the Red Cross's example, when you go back to that, that was really a risk. That could have come off poorly. And there are lots of examples of people trying to make a joke that people don't perceive it as a joke. And there may have been some people who were offended by that. These people could be alcoholics. Are you making light of that? So you have to be careful about how you post, and you have to figure out, is this in line with the way we put ourselves out there? A good policy I was going to suggest to go look at as an example is IBM's social media policy, and you could just put that into Google and find it. And there's some wonderful things in there where they talk about how your off-duty conduct, especially if you're an executive, can affect the organization. But it's kind of colloquial, which is interesting for IBM because you don't normally expect Big Blue to be Big Friendly Blue necessarily, but they are. And we looked at that when we were drafting our own company policy, and you have to write it in conjunction with all the other policies that you probably already have. Because in reality, social media is really not that different from what you've been doing with your website for years. There's plenty of wikis and blogs. There's plenty of I hate such and such company.com or companysucks.com. I mean, those sites have been out there for a very long time. So you need to look at what other policies you already have in place and try to draft something that links up with those.
Absolutely, and the policies that are drafted, the guidelines here are kind of, they are, it's hard to say in legal speaking, but they are kind of black and white. There are certain things that you can do and have in a policy, and certain things that you can't have in a policy. The board is now, again, it's ever evolving, but the board is now giving us, through advice memorandums, through general counsel memorandums, more indication of what we can and can't have as organizations in our social media policies. If we will turn now to slide 43, social media use guidelines. This just kind of runs through what you guys should look at doing in adopting and drafting a social media policy. My view on that, on social media policy, is short, sweet, and to the point, and have the ability to implement and follow it and use it as a roadmap to guide you in implementing your social media use through your employees. If you flip over to 44, we're continuing there with other tips on what to include in your social media policies. In 45, again, more tips to include in social media policies. And then on 46, finally, what the social media policies should have in them. On page 47, we finally get to what the end product is, and these are some tips of what to include, what not to include. Disparaging comments. So in your social media policy, it would not behoove you to put that XYZ organization will not allow employees to post disparaging comments about it online. That's something that an example where the NLRB would take a look at that and say that probably is in violation of the act, and now you've got a problem.
You could say something like, or could you say something like, this is the social media may not be the forum to air disputes.
Absolutely.
And could you say we encourage a professional atmosphere if you're?
Well, I guess it would depend on the dispute that's being aired.
I think sometimes people, at least I know I get confused because sometimes it's how you want your site to be run. So it's sort of, and the employees could be one of the potential posters. So you want to encourage people to get along and say nice things and not be mean to other people. But I also think there's the social media policy from you and your employees. So it's almost two different things. It's almost two different policies. So something to think about. I learned something new today,
and
too.
Also, the NLRB is going to take, for the most part, in interpreting a policy and interpreting conduct and interpreting actions, they're going to take a reasonable view. If someone posts something that they could possibly be acting for the on behalf of many employees, but at the same time it's many employees bullying another employee, the NLRB is going to look at that and say, well, why it may be not mutual aid and protection, but it may be concerted activity from the standpoint of it's a lot of employees acting for one cause. The cause that's being acted for is an unlawful clause. So I don't want to give the direction here that there's absolutely, from what it sounds like, gosh, there's nothing we can do to an employee that posts something on the internet. But in reality, that's not the case.
So net, static pages are the way to go.
There you go. I think that wraps it up. All right there. Hang on, we're
Are there other questions?
We're obviously here for questions, but.
Well,
Okay.
Thank you very much, everybody, and please call Pro Bono of Atlanta Partnership of Atlanta if you need some assistance.
Absolutely, I'll echo the same, and hopefully we created enough issues for you guys to keep Pro Bono busy. Sure, 2 questions. Sure, go ahead.
It seems like there are a lot of changes with the NRLB. It's more of a statement than a question.
Okay. That a lot of changes with the NLRB, absolutely. The NLRB was kind of quiet and dormant for a while, and then in the last 2 years, the NLRB has become, as we like to say around our office, they're back, and they're back with a vengeance at the moment. But it has, much like employment law took off back in the early '90s. The labor law is now coming back again, and now into the employment context as well. So, very accurate statement, yes.
Okay. Is there somewhere to keep updated about these issues?
Yeah, there is actually. The I'm sorry, is there anywhere to keep updated about these issues
In reference to, I guess.
in reference to what I'm assuming is the NLRB and their issues with social media? And yes, there is. You can update it generally on the NLRB website. If you'll go to the general website of the NLRB, you can find where the postings are for general counsel memos and advice memorandums. Companies sometimes will submit a question to the board, and an advisory committee will take the question in and will take it and will look into the different facts and scenarios and will issue an opinion based on the question that is posed before them. It's almost like if you're in litigation and you appeal a case to a higher court, they'll issue an opinion based on the findings below, and you basically issue, what is going to happen, what's likely to happen in this situation, and the NLRB will issue a decision and they'll post those things.
Are we good?
Yeah.
Okay.
Thank
great.
you very
Thank you.
much. I want to give this to you. This is our pediatric, and he's amazing.
Okay,
I don't know if
great.
he sees infants, but
Okay, great.
my